laughed at.
Yeah.
Right? When Phil and his team started making these motions, I mean, people didn't take them seriously, right? I mean, it's like, hey, you know. So that's what we're up against. And that's why we need the community support. That's why we need you solidly behind it. So anyways, I wanted to thank you and tell you how excited I am to be here. If you ever get in trouble in San Francisco, I don't think I call. But I was telling some of the lawsuits, if you're lawsuits here, we have a great program at the Public Defender's Office if you're interested in interning. One of the things that I've been involved in the last week is trying to hire actually 40 more attorneys, including 10 in our office, who are going to provide universal representation in immigration cases and get ready for whatever the new administration has coming on the 20th. But I'm really looking forward to hearing Phil's talk today. And again, I wanted to thank him for the great work that he's doing.
Good evening. My name is Phil Telfian. I am the executive director of a nonprofit called Equal Justice Under Law, and I'm also an attorney. That was a great reaction, actually. Usually when I say that, I get all sorts of boos and things thrown at me. So it's good that this is an audience that welcomes at least civil rights attorneys to the podium. So my organization is based in Washington, D.C. We actually started challenging the problem of debtors' prisons, fines and fees, folks who are pulled over for traffic tickets, parking tickets, and then when they can't afford their fines and court costs, they're often put in jail. So we filed several lawsuits, mostly throughout the South. The problem is everywhere. We filed lawsuits in Alabama and Mississippi and got some of these debtors' prisons shut down. And then we learned about an important issue that we're all here to talk about tonight, which is bail reform. So the fundamental problem with fines and fees is you get pulled over for some kind of traffic violation, you get a $100 fine, the court tacks on $150 in fees, now you owe $250, and if you can't pay it, some cities illegally and unconstitutionally throw you in jail. The problem with money bail is exactly the same. Just as Jeff and David have described for you all tonight, when you get arrested for a crime, you're given a bail amount, and if you can't afford it, you stay in jail. It's literally wealth-based detention and wealth-based discrimination. So we filed 11 lawsuits across the country challenging this equal protection violation. In the first 7 lawsuits that we filed, we got a lot of confused looks and phone calls from the city's attorney's office wondering how could money bail be unconstitutional. It's something that's been part of our country's history for hundreds of years. And the same question that we're all asking ourselves is how can racism be unconstitutional? It's been a part of our country's history for hundreds of years, and we threw that back at them. And folks started to understand exactly the problem with wealth-based detention, exactly the problem with money bail. So in our first 7 suits, cities actually settled, and we were able to change money bail practices in 7 cities across the country. Now, these were small cities that only dealt with misdemeanor jurisdictions, cities you probably haven't heard of, like Valdez City, Missouri, or Moss Point, Mississippi, or Clanton, Alabama. We started with the so-called small fish, municipalities that didn't make arrests for felonies. Those would happen over in the county courthouse. So our first 7 suits focused on these municipalities where it was misdemeanor based and where the cities were a little more reasonable. Then we actually got a call from Jeff Adachi's office who saw the work we were doing and said this problem is here in San Francisco. And thanks to the work of the Public Defender's Office and our own investigation, we saw just how big the problem actually is. There are over 100 people sitting in San Francisco's county jail right now for no reason other than they can't afford their money bail. They haven't been proven guilty of any crime. They're sitting in jail because they can't make that monetary payment. In San Francisco, every year, there are thousands of folks who sit in jail just because they can't afford money bail. San Francisco books about 18,000 people in their jail every year. 85% of these individuals are pretrial. So we came out to San Francisco and filed our first lawsuit at the county level, challenging not just misdemeanor detention, but also felony. We filed this lawsuit October 30th of last year, and let me tell you how it began. So on October 29th, I met Crystal Patterson. She was 29 years old, and before this arrest, she had never had any encounter with the criminal and justice system. She had never been arrested before in her life. She was arrested on October 29th of last year, about 13 months ago. Allegedly, according to the police, there was a family brawl, a family fight that it resulted in someone getting bloodied. For a lot of you, that sounds like Thanksgiving dinner. For Crystal Patterson, it resulted in her first ever arrest. She was arrested for aggravated assault because the police believe she was one of the instigators of this family brawl. She was booked in the San Francisco County Jail. Now, mind you, someone who's never been arrested before in her life, and told that she could walk free if she paid $150,000 in bail. So, like Jeff, I've looked at a lot of the bail schedules on the state, and San Francisco has one of the highest. A close second is Sacramento. Some of these bail amounts are enormous. She, of course, cannot afford $150,000 in money bail. She's a low-wage worker. She does in-home care services. She lives with her grandmother. Her mother experiences homelessness and unemployment, and so Crystal really is the sole caretaker for her grandmother, who's 80 years old. If any of you have an 80-year-old at home, you know that being locked in jail is not a good way to take care of them, and they're going to need your help. So Crystal was desperate to get home as soon as possible to take care of her grandmother. I met her then, heard about her situation, and filed a lawsuit in federal court. On the very next day that I met her, we asked for a temporary restraining order, and the judge set a hearing for that temporary restraining order. A temporary restraining order, for those of you who are not lawyers, is sort of an emergency motion. We've got a client who's in jail unconstitutionally. She needs to get out. It's a desperate situation. Ideally, it's something that can be heard that afternoon. It was scheduled for 6 days later. Crystal Patterson at this point is desperate, and so is her grandmother, who's home alone. So she does what, unfortunately, a lot of folks in her situation do. And what we saw in her case is an illustration how the poorer you are, the worse the system treats you. Now, if you're wealthy, or if you have wealthy relatives, you write a check for $150,000 and you post it with a court. That's money you'll get back. It's not out of your pocket. You just have to be able to float the money. And so for the very rich, they can do that. And they get to walk home and take care of their family right away. If you're poor and you can't afford that $150,000, you call one of these private bail companies. So there's a lot of misinformation about these bail companies. They call themselves bail agencies. Gives you the sense that they work for the courts, or maybe there's something official about their existence. They're just for-profit companies preying on poor people. So if you can't afford the full bail amount, you'll call one of these private bail companies, and they'll say, we'll get you out, just give us 10%. And of course, as Jeff explained, you don't get that money back. So the poorer you are, the worse the system treats you. Now, 10% of $150,000 is $15,000, which Crystal could not afford, and her family could not afford it. So the bail companies have a special offer. They reserve it for the poorest of the poor, which is pay us 1%. Get 2 co-signers and sign a debt agreement. 1% of $150,000 is $1,500. So Crystal called her aunt and her sister. They scraped together $1,500. All 3 of them signed a debt agreement. I've seen this agreement. It says that they'll all 3 be responsible for paying the balance of this $15,000 at the maximum interest rate allowable by law. I did some research into California law to figure out what that is, because the contract itself doesn't even say. So all 3 of these folks are now bound for $15,000 debt at the maximum interest rate allowed by law, which, for all we know, could change. It could go up. Crystal is in jail for 31 hours. She signs this agreement, painful agreement, only because we couldn't get our TRO as fast as we wanted to. She goes home to take care of her grandma after 31 hours. The district attorney's office in San Francisco, which actually compared to some other DA's office is actually a pretty good one, finally gets around to taking a look at her file. They read the police report, and they realize there's no evidence here. There's no basis to charge this crime. So they throw it in the trash. She's never charged with crime. Crystal Patterson to this day has never been charged with a crime in her life. But her sister, and her aunt are paying $200 a month on a $15,000 debt at maximum interest, and they'll be doing this for years, if not decades. The system is so bad, and the poorer you are, the worse it treats you. So our lawsuit is now before a federal judge in San Francisco who is forcing the sheriff to explain, how can this make sense? How is this constitutional? Well, just a few weeks ago, the sheriff and the city attorney in San Francisco came forward about a year after we filed our lawsuit, and they both said, we won't defend this unjust law, that money bail is unconstitutional. So it's a great moment for our case. It's a very exciting moment. The end of money bail in San Francisco is within reach. It's not a guarantee at all, because the judge herself, very educated, very reasonable person, I think will look at the case closely. And so the fact that our defendant, the sheriff of San Francisco, and the plaintiffs agree on the unconstitutionality of money bail won't itself be enough. Of course, the judge has to issue an order herself. Actually, the California Bail Agents Association, a group of private bail industries, is moving to intervene in the case so that they can defend money bail, and maybe that our case ends up turning against them. We've actually also filed a lawsuit in Sacramento challenging the problem here. I was born and raised here in Sacramento, and when I founded this nonprofit, I got to fulfill one of my lifelong dreams, which is suing my hometown. Great moment for me. We have a very similar lawsuit in Sacramento where the problem is just as bad. In Sacramento, folks are being held on money bail, again, not based on whether they've committed a crime, not based on whether they're likely to commit future crimes, not based on whether they're a flight risk, but simply based on their wealth status. In Sacramento, it's better to be rich, guilty, and dangerous than poor, innocent, and a contributing member of society. Our client in Sacramento is a fellow named Gary Welchin. He was experiencing homelessness earlier in January this year, and he broke into an empty house, a house that was under construction. It's a crime. I do a lot of work with homeless populations. It is illegal to break into an empty house, even if no one lives there. Smash the window, and of course the neighbors called the police. Unfortunately for Gary, he broke into a house in the wrong neighborhood. It was a wealthier neighborhood where folks were looking out. He got taken over to Sacramento County Jail and was held on $30,000 in bail for a crime that was later determined to be a misdemeanor. He's there on a misdemeanor for 6 days simply because he can't afford $30,000 in bail. The system is completely broken. David and Jeff are right. There is an alternative. It's so funny when we talk to folks about our lawsuits, they're always asking, well, what's the replacement? What's this? As if the United States and the Philippines got together in a room and thought, there's nothing else out there. This is the only thing we can possibly think of is money bail. As if there's not models that work anywhere else. Well, luckily, where my nonprofit is based in Washington, D.C., there's a system that is better. In Washington, D.C., if you're arrested, you're not told there's a price tag for freedom. Instead, everybody, rich and poor, is treated the same. Now, in the vast majority of cases, it's a cite and release. If it's a nonviolent crime, if there's no victim, you're given effectively a ticket, like you would if you were pulled over for a traffic stop. Even for criminal offenses, you're given a citation, and so come back to court next Thursday, or something of the sort. And the overwhelming majority of folks actually do. We have the statistics in Washington, D.C. to prove this. Close to 100% of folks are coming back to court. What we're finding is not that people want to be fugitives of the law. They're not trying to escape their court dates, because often being a fugitive carries much, much, much more severe penalties than whatever crime you're accused of to begin with. Now, for some serious crimes in Washington, D.C., you're held. And within 24 hours, you'll be brought for a judge. Now, again, rich or poor, you'll be detained if you're arrested for a serious offense in Washington, D.C. So you can't buy your way out. But you'll see a judge within 24 hours, and that judge will determine whether you're a flight risk or a danger to others. In 92% of arrests in Washington, D.C., that determination is you're free to go. So 92% of arrestees in Washington, D.C. are actually released pending trial. Makes it easier for them to prepare for their defense, to meet with their public defender, to gather witnesses, and actually, folks in Washington, D.C. do a lot better in terms of conviction rates than they do in a lot of other cities, because they're not sitting behind bars being coerced into guilty pleas that they feel is their only way out of jail. There's definitely alternatives. What I want to put forth for you today is a couple of other options. I actually think Washington, D.C. even then over-detains people. This is a controversial view, but why are 8% of folks in Washington, D.C. being detained before they've been convicted of any crime? And this asks for a philosophical and fundamental question about our democracy. We were founded on the notion of a presumption of innocence, but it means absolutely nothing in the United States. It carries no legal weight. And whether you're innocent or guilty is determined before you've gone before a jury. The court considers you guilty when you're arrested, and our society considers you guilty when you're arrested. Our society is afraid of folks who've been arrested. There's a presumption that if you're arrested and you're poor, you must be dangerous. It's a deep, deep form of implicit bias. People ask all the time, well, what are we going to do if we can't detain folks who are arrested? We're going to do the same thing we do with other folks we can't detain. We're going to put money into education. We're going to put money into information, into drug rehab programs, into alcohol rehab programs. We're going to do all the resources that we know work to make society a better place. But for some reason, there's the assumption that once the government has their hands on you, they can do whatever they want. When I was growing up, there was this movie, Tom Cruise movie, called Minority Report, which was this idea of a crystal ball, right? If you know someone's dangerous, surely you can then lock them up. And Steven Spielberg makes this movie to convince us all, well, no, even if we had a crystal ball, it's a free society and folks shouldn't be kept in jail until they've actually been shown to have committed a crime. Well, that's the philosophy, that's the opposite of our philosophy in our current criminal and justice system. Folks who have not been proven guilty beyond a reasonable doubt are under the assumption that we can hold on to them just because we think they're dangerous. So the question we should all be asking ourselves is, under what circumstances can we put someone in a cage? Under what circumstances can we lock them in a jail cell? For most of us, the answer is if a jury finds them guilty beyond a reasonable doubt, or maybe if they've pled guilty to a crime, then we'll punish them with jail. Why is it that so many folks, thousands of people every year, are in jail cells before they've been adjudicated innocent or guilty? Even in a town like Washington, D.C., which is a better system, it's not wealth-based. Why is it that so many folks are sitting in jail before they've been determined guilty? And then the last thing I'll ask you to think about has to do with what's going to happen when we end money bail. And I say when because I'm very confident that the system will come to an end. The DOJ has filed statements of support in our cases saying that money bail is fundamentally unfair. I told you about the Sheriff of San Francisco. The state of California's State Supreme Justice has appointed a task force to look into replacements to money bail. Rob Bott is proposing legislation. I think money bail will come to an end. But what's going to happen next? As David pointed out, supervised release pretrial is a form of probation. Well, some of the work that we've seen, we filed a lawsuit in Tennessee against privatized probation. And that's what I worry is the replacement. So I want all of you to be on the lookout for this replacement. We sued a company called Providence Community Corrections, PCC. They're a private probation company in Murfreesboro, Tennessee. If you can't afford your court debt in Murfreesboro, you're assigned to PCC to be your probation officer. Now, public probation, the purpose is reintegration, rehabilitation. You're often put on probation after you finish your jail sentence, and your probation officer is supposed to help you find a job, help you find an apartment, support what they call pro-social relationships, family relationships, other kinds of supportive relationships that will get you back on your feet and become a supportive member of the community. Private probation is exactly the opposite. It takes away all the resource you have to become a contributing member of society again. So PCC charges its indigent probationers $45 a week, which is the maximum allowable under Tennessee law, to be on PCC probation. It then charges them $25 for every drug test. The drug test costs about $1. It charges $25 because they're a private for-profit company. So everything they do has a profit margin built into it. And it's their probationers who are paying for it. They issue their drug tests at random, at their own discretion, for crimes that have nothing to do with drugs. They assign people electronic monitoring at a charge. They assign people to AA or NA, Narcotics Anonymous classes, at a charge. They make all of their money off the probationers. Why does this model even exist? Because before PCC came to Murfreesboro, Murfreesboro had its own probation department. It had 4 probation officers on the county payroll. And PCC said, fire all those folks and hire us. Murfreesboro said, well, we don't want to do that. How much is it going to cost? And PCC said, $0. We're going to make all of our money from the indigent probationers that you assign to us. It's going to cost Murfreesboro absolutely nothing. And so, like so many cities and counties in Tennessee, they got rid of their public probation department and hired private probation companies. These companies abuse the rights of all of their probationers. We filed a lawsuit over a year ago.